The chapter on constitutional law is thorough enough that I'm not going to add much to this chapter, but there are a few concepts that I will touch upon and one or two that I will add to the chapter. For example, the concept of standing. That's the notion that for a person to be able to bring a case to court, they must have sufficient standing to sue, meaning that they've got to have a sufficient stake in that controversy to obtain a judicial resolution of that controversy. And typically, especially when you're talking about constitutional law, we've seen this in the news recently is why I'm addressing it. Individuals complaining about how various tax funds are used, how the government spends money. Typically for a person to be able to sue claiming that a particular law or action, governmental action, violates their constitutional rights, they've got to show that they specifically are going to suffer or are suffering some particular injury that would set this individual apart from others. And generally you cannot assert the constitutional rights of another person. There certainly are some exceptions. For example, when a person is unable to assert their own constitutional rights, maybe due to some form of mental incapacity. But as a general rule, an individual can't claim someone else's constitutional rights are being violated. They've got to personally, specifically, be suffering some injury. Another concept that's worth touching upon, notice for the Commerce Clause to apply, it requires very little. You've got a case addressed in the book, the Wickard case, that shows that doesn't take an awful lot for this clause to apply. In this case, it was a farmer who they were told how much wheat they could grow, and this individual grew more than he was allowed. He was fined $117, and his complaint was that he did not impact interstate commerce. And the Supreme Court held that even though he did not sell the wheat, he used it on his farm, it did have some impact on the overall wheat market. And even though it was trivial, it was still subject to federal control. So it doesn't take a lot for the Commerce Clause to apply to a particular set of circumstances. The Supremacy Clause is one that's been in the news a lot over the last few months and actually even years. This says essentially that if an issue arises that where there's a conflict between state law and federal law, that federal law will apply, and that is just that's the general rule. We've certainly seen some exceptions in the last few years, certainly with respect to laws pertaining to immigration, where federal law did not trump state law. Next on the list, let's see, freedom of speech. And I'm looking, if you're wondering what I'm looking at here, this is the summary of items, the checklist that I've provided to the class. I'm just looking at some of these items that are worth explaining a little bit. Freedom of speech you need to be generally familiar with. Certainly that is one of our most important freedoms under the U.S. Constitution. And the textbook does a reasonably good job of addressing free speech issues. Time, place, and manner restrictions. These are restrictions that are generally deemed as valid restraints on our speech. There are 3 requirements for a valid time, place, and manner regulation. One is that the regulation allows substantial other opportunities for the speech that's in question to take place. So if I'm being prevented from speaking out against the war in Iraq, then one of the things that would be looked at is does this restriction, whatever it is, does it give me other opportunities to speak out against the war? So that's one requirement. Second, the restriction must be content neutral, meaning it doesn't say who or what can't be spoken, doesn't say who can't speak or what can't be spoken. And the third requirement for a valid time, place, and manner regulation is that the regulation must serve a significant state interest. And this would be something like safety, anything that provides for safety for the general public or in some way protects the general public or is in some other way for public welfare. That would be generally construed as a significant state interest. There are several types of speech that can be restricted solely because of the content of that speech. Speech that is deemed to be obscene, speech that is defamatory, speech that constitutes false or deceptive advertising. Those are just a few of the types of speech that can be restricted solely because of the content of that speech. And sometimes cases arise where maybe a state or a municipal government where they've tried to restrict speech. For example, there was an incident, I believe it was Massachusetts, within the last few years where they tried to restrict individuals from using cuss words in public, and a statute like that quite often will be deemed to be vague. And sometimes a term that's used is that the statute is overbroad, meaning that it's attempting to prevent something that can legitimately be prevented, something like obscenity. But not all cuss words are obscene, so it's prohibiting even more than would be constitutionally allowed. Depending upon what the restraint is attempting to prohibit, for example, maybe the law attempts to prohibit cussing in public or foul language. If the statute does not specifically explain and state what it is that's being prohibited and what it is that might land you in court, that restriction may well be deemed to be vague and overbroad. Overbroad is the idea that I'm attempting to prohibit something that is on this list of things that can be prohibited, such as obscenity. However, I'm actually prohibiting a lot more because not everything that is that might be deemed to be cussing would be deemed to be obscene. So it's overbroad. It's going beyond what can legitimately be prohibited. What can be prohibited is obscenity. And if you're not put on clear notice of what it is that you're doing wrong, for example, if you've got a noise ordinance that says that you can, it's a misdemeanor if you create loud noises. Well, that doesn't tell me what loud is. A statute like that would have to very specifically state what the decibel level would be. What is exactly deemed to be a loud noise? Otherwise, and if it doesn't do that, then the statute would be deemed to be vague. It wouldn't put me on clear notice of what it is that I can't do, and would therefore be in violation of due process. The idea behind due process is fairness and notice. And if the statute is vague, then arguably it violates due process. Another concept that needs to be addressed is eminent domain. And we've seen that issue dealt with right here in Johnson City when the city took over some property owned by U-Haul to improve the drainage in the downtown area. In the past, we've had a lot of problems with flooding. We apparently still occasionally have some problems with flooding, but it's not nearly as bad. The city took over the property, and whenever eminent domain is being exercised, the reason for the government taking over that property has to be for the public good, and certainly preventing flooding is for the public good. And the individual who owns the property must be paid just compensation. Ideally, and we don't live in an ideal world, but ideally, just compensation would be fair market value. Although if you remember the facts surrounding the takeover of the property that U-Haul owned downtown, one of the issues was that the city was not paying them an appropriate amount of money. That is not uncommon. A couple of other topics that need to be touched upon, previously addressed due process. It would be worth taking particular note of what exactly is involved with the concept of due process. There are two types of due process. One is typically referred to as substantive due process, and the other procedural due process. Substantive due process is just the general notion that the statute on itself, or on its face, the statute itself must be fair and reasonable. It's just a fundamental concept of fairness. Procedural due process essentially says that whatever procedure is being used to take your life, liberty, or property, that procedure must be fair. And again, this notion of fairness comes up. So due process is all about fairness, some fair process or procedure being used. Typically, part of that is that the decision maker must be neutral. They must be an unbiased decision maker. So if you're bringing a case before someone for a hearing and that person has some stake in the controversy, arguably that is not an unbiased decision maker and due process would be violated. So fairness, notice is also a concept that comes into play. As I mentioned a few minutes ago, if you've got an ordinance that prohibits foul words being used in public, prohibits cussing in public, the statute typically would not put you on notice, that ordinance or statute, whether it be a local ordinance or a state statute, that it would not put you on notice of what it is that is being prohibited. And that vagueness in itself would arguably violate due process. Now, the most process that could be due a person would be a full-blown hearing, a full-blown trial, where you have legal counsel and all the procedural protections afforded under a full-blown court trial. And again, due process comes into play when the government is taking away one's life, a liberty interest, or a property interest. If any of those are at stake, then the court looks to see what process might be due you under those circumstances. The other topics are addressed reasonably well in the textbook, and the other topics that are addressed on the checklist should get some attention from you as you read through the chapter.